who is before this honorable court.
Your Honor, I'm wondering, should we not, we're here for the accused party before he proceeds, because we have something to say. Maybe it would be proper for us to get on record first, because we are actually objecting.
So you are
for the accused person first. I mean,
for
sorry,
the
for the suspect, the respondent in the application.
So you'll be objecting after they make the application. This is not the procedure. So let them make the application, then you raise your objection.
Yes, but one check for him, because it should be not order. If he proceeds, then I have to introduce myself. So my name is Muge, and I appear together with Honorable Jerry Minor.
Present.
Mr. George Sakimpa.
I'm present, Your Honor.
Mr.
George
Sakimpa.
Sakimpa.
Yeah, Sakimpa. It's with a P.
Yes.
Mr. Bernard Geritu.
Present, Your Honor.
And Mr. Patrick Kum.
Present, Your Honor.
Bernard Richo Patrick
Kum.
Yes. For the respondent.
For the respondent in the matter.
So that we have some order before they make the application.
Yes.
We'd want to get to know the lead counsel, whether yourself, Jerry, Gerito, or any other person.
Yes, I am lead counsel from Mr. Mugi.
So the lead counsel, so you're the one who is going to do the response.
Each party, we have divided ourselves. Each party is handling particular.
Well, we don't want to be here forever.
Yes, we've been here before. We will manage our time.
Yes, no. I have some matters ongoing.
Yes.
Okay?
Yes.
Before court number 5. So to save on time,
Yes.
kindly let them write some few notes
Your
for you
Honor.
to say.
Yes, Your Honor.
Yes.
And I understand why you might be saying that. But these are actually two applications.
So you agree that you're maybe responding to one, maybe Jerry will respond to the other.
We're also making we're also making further applications. One of the applications we're making is to cross-examine the opponents of
Wait, they have not even made the application, Counsel.
Yes.
What are you cross-examining on?
Once they raise the application.
What you do?
Yes.
We are at the point whereby we need to agree as to who take what application. So if you agree that yourself take up this one and Jerry or any other counsel takes the other, okay? Then we leave it at that, so that we don't have everybody speaking and repeating. Okay?
We will not, Your Honor, we will not speak and repeat.
Let me hear from
Yes.
Jerry. Jerry, you agree with
Your
me?
Honor,
Yes.
Jerry Minor,
Yes.
I think we agree, but we'll try manage our time.
Yes.
Perhaps the point that Mr. Mugi is trying to pass across is that we have divided in regard to who is doing cross-examination, so we don't also
No, let's have one
become
person,
repetitive.
okay, doing it.
Per application.
No, the response to this application and another one doing the response to the other application.
You know, I think perhaps we'd like to seek guidance because we had prepared, we've just been served.
You are
and
prepared, but we have given directions as to how this matter will proceed, Jerry. So agree as to who is vocal or whoever you want, okay? Those are the rules. If it is him, let him take up one matter, yourself one matter, right? Before we must have some order.
Most obliged, Your Honor.
Yes,
We will
thank you.
figure it out. Thank you.
Jerry. So I've recorded that Mr. Muge is the lead counsel in E791 of 2026. So, Mr. Sonia?
Yes, Your Honor. The application before you is one dated 5th of today. And it's go through a notice of motion. And
It's dated one or today,
dated
5th
today,
of
5th of August.
yes.
It's brought by National Probation Protection as the applicant against the respondent Justin Kinyua Mwangi, who is before this honorable court. The application is supported by the affidavit of Corporal Cyrus Keter, who is a DCI Headquarters.
You say Corporal?
Corporal Cyrus Keter, number 83476.
Yes.
He supports that application for orders that this court do issue the DCI investigation digital forensic laboratory to conduct forensic examination.
With, you are too fast, DCI with?
That this court do authorize the DCI investigation digital forensic laboratory to conduct forensic.
Digital forensic laboratory?
Yes. To
Yes.
conduct forensic examination, extraction, analysis of all electronic devices, SIM cards, social media accounts, cloud-based accounts associated with the respondent, and any other digital evidence relevant to the investigations that they intend to carry. Number 2, to issue an order compelling the respondent to disclose to the investigating officer before the court, Cyrus Keter, all the passwords, codes, login credentials,
Passwords? Codes?
all login credentials for purposes of cyber analysis and extraction of data by the DCI Digital Forensic Laboratory. And number 3,
Yes.
for this court to issue an order compelling the DCI Investigation Digital Forensic Laboratory,
To issue the DCI.
yes, to give to Corporal Cyrus the investigation attached to
I'm not getting it. The court to issue?
the court to issue and compel the DCI Digital Forensic Laboratory to make and give the IO before this honorable court an investigation, and the investigator.
Please, you say address court while, looking here so that
Yes, yes,
you
okay.
don't leave me behind.
Yes.
You say digital forensic laboratory?
Digital Forensic Laboratory
Yes.
to make and give Cyrus Keter, the investigator, a certificate of production of electronic evidence under section 106B4 of the Evidence Act.
Yes.
Your Honor, those are the orders we are seeking,
Yes.
and if you will indulge the prosecution as the applicant,
Yes.
so that the investigator can expound on one or highlight one or two things important that he may feel the court needs to know why he needs these orders under oath.
Sorry.
No, Your Honor, before we proceed,
Yes.
we are objecting to the application, so I would like to make the objection because it must be determined in limine.
Yes.
It goes to jurisdiction. The application before you is under section 36A.
Let me know what you are objecting to.
Yes.
That he should take an oath.
No, I'm objecting
They are
to
not done. with the application.
No, he cannot take an oath before we deal with the application, which goes to jurisdiction, for this matter to be heard at all.
So what is your objection?
My objection, Your Honor, is under section...
Wait.
Yeah.
Mr. Muge,
Yes.
you object to?
The application being made at all and the jurisdiction of this honorable courts to hear and determine this application
Yes.
The application is being made by the prosecution as admitted and under Article 49(1)(f) and G and Section 36A.
The say it's being made
Yes.
under Article
49(1)(f) and G, read together with Section 36A of the Criminal Procedure Code. Section 36A(2) is very clear on who makes this application. The application is to be made by a police officer, not the ODPP. And yes, the application will be supported by the affidavits of a police officer under 36A(3).
You're saying that it should be made by the police officer and not
Yes.
ODPP.
And then not ODPP.
Yes.
As a matter of fact, Your Honor, the ODPP in matters pre-charge are not even seized of the matter. We are at the investigative stage of these proceedings. They have no standing before you in this matter. And we are aware that such applications have been made before based on practice. Our objection is on jurisdiction to be determined in limine. These applications by Section 36A must be made by the police, not the state. And we would like a decision on that application before they can proceed.
Over the agenda, Mr. Sen.
You know, we are proper before this honorable court. It's been practice that such applications are made through the ODPP. The police, when he wants to vent his arguments, he has to do it through the ODPP. And I do not see any gaps in the application, and I wish to reiterate that we are proper before this honorable court. The DCI and the police has to tie down through the ODPP so that justice can be dispensed. This is the channel. There is no any other
You know, when they raise the issue of jurisdiction, Mr. Sonia, we have to determine it, unfortunately.
Yes.
And I wish they would have even raised it before we write so much and get tired.
Your Honor, that is
Exactly.
that is what we wanted to do, but you said...
No, you did not. You
I
did
told
not.
you we
You
were going
just
to
realized that you need to raise it midway
No.
when they are tempted to call the investigating officer to swear. So we will deal with the issue jurisdiction first.
Yes.
And
Yes, and I would like to quickly join on our objection. There's nothing, Your Honor, about practice. The law is clear, and it reads, I will read verbatim. And this is 36A(2) of the CPC. And it reads,
wait. Mr. Mwangi. Section
36A. And 6A2. I read verbatim. Notwithstanding subsection 1, if a police officer has reasonable grounds to believe that the detention of a person arrested beyond the 24 hours period is necessary, the police officer shall, it is a police officer, produce the suspect, he has been produced, and apply in writing. It is the police officer to apply in writing, not the ODPP.
yes.
And so, and further at 3, that an application under subsection 2 shall be supported by an affidavit sworn by the police officer, the very same police officer making the application in writing. Nobody else. The words are mandatory, shall, and has nothing to do with practice. So, on your honor, on that objection, we pray that the accused person be released on reasonable bail, pending charge.
Are you making a bail application or you are opposing jurisdiction? I mean,
I have opposed jurisdiction, and that is the end of our application.
so we
At
do
the
a
end of
ruling
it,
on the
yes,
same
yes,
on whether this application be made by the DPP or the police
Yes.
on the 6th.
yes. And in fact, Your Honor, from what Counsel said,
Yes.
that the police always make, even for bank accounts, applications, check bank accounts, they always make it themselves. It is not the ODPP that makes it for them. And
I don't want to preempt, just sit down, I'll do a ruling.
yes, but
I'll do a ruling.
yes, but on the National Police
I
Service, from
have
what
been
he
in
said,
practice as well, so I'll do a
Yes.
ruling
just one thing,
based on practice and provision of the law. So sit down, Mr.
yes,
Mwangi.
but just to
So
be
you are
clear,
ruling on the 60th, or I would have done this afternoon, but I'm too busy. So I'll do on the 60th of August.
but Your Honor,
So that when we make a determination whether the application is proper before court, then we
Yes.
can proceed with the
Yes.
application.
which is fine, Your Honor, but today is 24 hours he has been here, and because he is before you, we are making the application for his release today.
This is not seeking to detain him. Why are you mixing
It
issues?
is,
There are two files.
yes,
Counsel, have you read this one?
I have read it.
So what is the order seeking to detain him?
For 10 days.
Where?
The application seeks to detain him for,
No, Mr. Muga, you are confusing us.
yeah?
These are different applications, Mr. Muga. Sit down.
Okay, fine, on that one then.
Yes.
E792 of 2026, Justin Kinyua Mwangi.
Okay, Your Honor, once again, the same.
This is the one for Jerry, or you are still the one on the lead in this one?
I'm lead all the time, Your Honor, for the
So
accused person.
Mr. Muga,
Yes.
let me record because this is a different one.
Yes.
This is Mr. Muga appearing with Jerry Maina. Let me come again so that we record. Oh, they are not in this
Yeah.
one.
George Sakimba,
George Sakimba,
Bernard Nderitu,
proceed.
and Mr. Patrick Kung.
Patrick Kung. That's it. How do you want to proceed with this one, Sonia?
Your Honor, let me be noted that this is a notice of motion dated the 5th of August today, drawn by the Office of Director of Public Prosecution,
Dated?
dated 5th of August. The application is brought under Article 49
So if I know Mr.
Yes.
Muge has read the application, you are raising similar objection?
Yes, so we'll just adopt the objections.
Yes?
We'll adopt the same objection?
No, I want to write.
Okay.
Yes. These
So-
are different matters.
Yes.
So means now that you have talked about the application,
Yeah.
let's hear. If he's raising an issue jurisdiction, we first consider that one.
Yes.
Yes.
So, Your Honor, I'm raising an objection that goes to the jurisdiction of the courts.
Is it the jurisdiction of the court you are challenging or the jurisdiction of the
Yes,
DCP?
the jurisdiction of the courts to hear and determine an application made ultra vires by the ODPP under section 36A of the CPC, Criminal Procedure Code. On the ground,
You say that is 6?
A of the Criminal Procedure Code, which they ground the application on, seeking pre-charge detention of the respondents on the ground that this application can only be made by a police officer and not the DPP. And we rely on 36A subsection 2 and subsection 3, which provide in mandatory terms
Or which act?
of the Criminal Procedure Code, which provides in mandatory terms that an application for pre-charge detention shall be made by a police officer in writing, and that the application must be supported by an affidavit made by the police officer making that application. The ODPP is pre-charge, not yet seized of the matter, and does not represent the National Police Service, who in legal matters are represented by the Attorney General, not the ODPP.
So you are saying that the police are
Represented
by
in legal matters either by internal counsel or by the Attorney General, not the ODPP.
yes.
That's the application. I mean, Your Honor. And Your Honor, once again, because they seek for pre-charge detention, we
You
seek
made
for...
the application first, then we hear what he has to say. Mr. Soni?
You know, we've reiterated.
Because I'm just wondering, Mr. Muge, why do you want to prosecute the application and you are seeking orders before a court that has no jurisdiction? It can't work that way. It is either have jurisdiction or not.
Your Honor,
So that
I
issue
said-
must be
Your Honor, I
determined
think
first.
we are misunderstanding each other. I say
We are
you have
not.
no jurisdiction
The record is very clear.
to determine an application made ultra vires. You don't have jurisdiction to determine that application.
Yes, I understand.
Yes.
And in simple terms, I'm saying, and I asked you, are you saying this court has no jurisdiction? And you said yes,
Yes.
that you raised an objection that goes to the jurisdiction of the court,
Yes.
okay?
Yes.
In determining the
Yes.
application.
Yes.
So if I got your words clearly, you are challenging the jurisdiction of this court
In regard to the application.
to the entire application.
Yes.
Proceed.
You know, just to reiterate, we are the authors of this application, the Office of Director of Public Prosecution. They are the ones who have signed this application. And the court has to, we invite the court to look once again at the articles that have been cited in the notice of motion. And we speak for the public, and the public speaks through the criminal justice system, which has a chain.
You speak through? You speak for the public.
We speak for the public. and there's a chain.
Including Mr. Muge, it's also a public.
He's also public.
Speak for the public, yes?
Yeah, so we are the advocates for the public.
Yes.
This is the path. There's no any other path. So if he wants to insist on his argument, justice will stop.
But if you want,
If he wants to insist on his path, then we will not have justice. Justice will stop. There has to be a way out.
yes, Mr. Muge, or you are not you're still on your feet?
Yeah, no, that's it.
Yeah. In quick
Because
rejoinder,
I was simply just responding to his objection. I
Objection,
cannot
yes.
go further.
Which is an objection.
so
So
Your
before
Honor,
you cannot both stand, so somebody should give Mr. Sonny some seat. Ule mzungu wako mwisho si ngoje utoke prosecutor akae.
so Your Honor, in quick rejoinder, Your Honor, in quick rejoinder, he does not represent Kenyans at all, but only in matters where the state is a complainant. And once again, there is no charge before you. There is no accused person before you. And that is the only time the state will be before you. The section is mandatory. The application shall be made by a police officer, not the ODPP. They can approach Parliament to amend the Act, the code, but as it stands, police officer, not the ODPP. Much merit.
We both do rulings on the 30th of August. Should we find that the court has jurisdiction to entertain such an application, we will proceed. Should we not, then we'll give further orders. Between, do you have the cost list for the 6th? We could maybe between 11 and 12. Between 11 and 12. Right? So that, call out the other, please.
Your Honor,
Yes, Ms. Njeri?
I think it would be very prudent. There's no charge sheet before you, Your Honor, which is apparent on the record of this court. Your Honor, this is a holding charge. They were making an application that you have said you will determine at a later time, which will be past the 24 hours.
You see, of course, that is, something that you should approach the High Court, not this court, when it comes to 24 hours. The challenge, Jerry, you were keen. What has been raised by Mr. Muge, your counterpart, is that we totally have no jurisdiction. So I cannot determine anything sought in this application unless I determine that I have jurisdiction to deal with this. If you have a problem with that one, the High Court is happy.
Your Honor, that is to do with the application. I think it was very clear, and we've all heard, Your Honor. It would be very.
But Jerry,
I don't know how to
I don't know whether you were keen like myself. I've asked counsel. That's why I asked, are you still the lead counsel? And he said yes. I raised an objection that goes to the jurisdiction of the court in hearing and determining the application made by the ODPP. This is the application.
Very well, and it is good that you have said determine the application.
Yes.
It is in regard to the application.
Yes.
He has not at any point raised any issues in regard to jurisdiction pertaining the suspect being released by this court.
I don't know whether I'm the one who was not in a group of schools, but Njeri, the order you are seeking is in the application, is it not? Or maybe you have not read it. Seeking to detain this person. It is part of this application. Whether to detain him or not, go to jurisdiction as raised by Mr. Muge.
Your Honor, if I may.
Let me do the others.
Your Honor.
There was a lead counsel, very learned counsel, Mr. Muge.
This matter, Your Honor.
No, I will not
And I
allow you.
respectfully-
Sit down. Give me this one, then you'll address me later. Give me this one.
Your Honor, it goes to the rights of the accused, and he is before you. That application was made by the BPP. We have dealt with that application.
So are you saying that he should now make an application to detain?
No. The accused person is before you. And Article 49(1)(g), After 24 hours, when the accused person is before you, he has the right to be released on bail. And we are making the application that he be released on bail unless there are compelling reasons holding him
Let me
here.
hear Mr. Sonia.
That has nothing to do with the application.
Sit down. Let me hear Mr. Sonia.
You know, the accused has been brought to this court
Yes.
because of this application. It's been brought in a package. This package has to be dealt with first, so that before any other issue has been dealt with. So I concur with you that first of all dispense with the objection issues that have been brought to the court, and then we can go in that order. So that
Somebody else with a different opinion and not the defense counsel, Mr. Allo, is also an able prosecutor.
Somebody is arguing that I was not on record, and I'm wondering if
Whether you respond.
Yes.
We are not writing.
Well, the accused person is part and parcel of the application. So you cannot isolate the accused from the application. Then the bar orders specifically for the accused. We've complied with 24-hour rule. We've not broken any rule. But now they want a special order of actually releasing it before the issue of jurisdiction is determined.
Whatever they do with the accused before this application is heard or determined is neither here nor there, because I have no jurisdiction as far as Mr. Muge is concerned. And
Your Honor, you keep misconstruing what I am saying, and it is extremely unfair. The application was made by the state. We are opposed to that application. That has nothing to do with the accused person. The accused person is before you. And once he is brought before court, you must, Your Honor, determine if there are any compelling reasons to hold him in a cell.
Just sit down and come back to you. Let me have this other one so that we don't keep so many people waiting.
Kelvin Mudedia Wairaira.
Please let's be orderly.